Good morning, Mr. Maidman.
Good morning. Please, the court. Let me begin by saying that the main issue in this case involves the denial of a pre-appeal motion for a new trial. The standard of review would be substantial likelihood of miscarriage of justice, and I would suggest to this court that if the court believes the substance of Alan Robillard's affidavit, the forensic document expert, then the defendant is entitled to a new trial.
Mr. Maidman, can I ask a question I probably should know the answer to, but I took, and I wasn't clear entirely what the reference was, but I take it, did the defendant have a handwriting expert at trial and
Yes.
decide not to call him or her?
That is correct.
And
The
but it
handwriting
wasn't
expert
Mr.
was, no, the handwriting expert was Mr. Robillard.
Oh, it was Mr. Robillard.
That's right.
Yes.
Okay.
But he did not testify at trial. And that...
He was there.
No, he was not in the courtroom at the time.
Okay. But, I mean, there had been extensive discussions and...
That's correct, Your Honor.
Well, he was available to testify, but defense counsel, according to his affidavit, elected not to call him.
Yes.
Well, doesn't that resolve it?
No.
Why?
It doesn't resolve it because the Commonwealth's forensic testimony was so unreliable and so misleading and so erroneous that it, in effect, amounted to a denial of due process.
Well, doesn't it just go to the weight of it?
I think under the circumstances of this case, if you take a look at what Robillard says in his affidavit, the level of detail in this, and his analysis of the Commonwealth's evidence, this court cannot be comfortable under under its obligations under 33E with affirming this conviction.
Well, if may I?
Yeah, go ahead, please.
If we agree with you, does that mean defendants don't, they can have their experts available, not call them during the trial, and then attack it afterwards, and they're entitled to a new trial? That seems to be what you're saying.
Your Honor, the facts in this case are extreme. I think that's the only way I can explain that. I understand
No
your point.
claim here of ineffective assistance. There's no claim here of ineffective assistance of counsel, is there?
That's correct, Your Honor. I think that...
Well,
no,
isn't that the only way you could go?
Yeah.
Your Honor, I don't believe there's a, based on the record in this case, I don't believe there is a claim of ineffective assistance of counsel. The problem, and more than that, all of this evidence was not newly discovered evidence. I would
that's
suggest to the
clear.
court that no ordinary fallible lawyer would have ever understood just how bad this evidence was that was introduced by the government. Until Alan Robillard saw the testimony, as he explains in his affidavit, he was troubled, and he went through it. 31 pages and 126 numbered paragraphs going into just how erroneous this testimony was.
But defense counsel knew what this testimony was going to be like coming up, and he cross-examined the witness, the Commonwealth's witness, on many of the points that are raised in Robillard's affidavit, and he was satisfied that did the trick. The witness really had been significantly impeached.
Your Honor, I don't think I'm in a position to critique the trial counsel on this. I would suggest, though, that when this court takes a very careful look at what happened in this case, at least with respect to the forensic testimony, that you should be very troubled by what happened.
So what would the rule be going forward? I mean, what would the holding in the case be for lawyers in the future?
Conduct of counsel in this
Yeah.
circumstance.
It would seem to me the conduct of counsel would... I'm not sure the focus is on the conduct of the counsel.
But it has to be.
I guess the rule would be, wouldn't it, that if the Commonwealth presents an expert witness who's thoroughly cross-examined and so forth, even though you have your own expert and choose not to call him, if the evidence is so fundamentally weak and flimsy and maybe to the point of almost deceptive, it's a violation of due process.
I think that's an excellent statement. I agree with that.
And that you say, when we read this transcript, we will come away with that conclusion.
Your Honor, I don't want to express my own personal opinion, but I don't understand how reading this you could not come away with that opinion.
Is the handwriting, there were other witnesses who testified, lay witnesses, who testified that the handwriting on that reverse piece...
No, that's correct. That's correct. Let me
was the defendant's, right?
well, that there was that testimony. That's correct. But if you take a look at Mr. Robillard addresses that. Fabrications are supposed to have a pictorial likeness. And the Commonwealth's witness, the Commonwealth's expert witness, paid absolutely no attention, and that's in the record, to whether this was a fabrication. She violated the professional standards. She expressed an opinion that's inconsistent with the professional standards.
But the question is about the lay witnesses. There were
I'm
lay
asking that.
witnesses.
The lay witnesses looked at Exhibit 10, which was the photograph.
Q, whatever it's called. The photograph. The
Well,
photograph.
a photograph, a digitally altered photograph. And one thing I would suggest to the court is you ought to look at the photograph yourself. You ought to look at the original, and you ought to look at the photograph. It'll be much more comprehensible to you. When you see the original, it looks like a smudge. As a matter of fact, I believe in the record he tried to get her to say that it was a smudge.
Right.
When you see this, you will better understand why Mr. Robillard is so upset about this.
But didn't all this come out in cross-examination? I mean, didn't the jury see all these things that you're talking about?
The answer is, in my opinion, the answer is no. Certainly not to the extent that I expressed it, and certainly not to the level of detail that I expressed it in the affidavit.
Well, apart from the affidavit, wasn't the witness questioned about the differences between the amplification of the signature and the original signature, and all the different things that can go wrong in that transformation?
There were, but it was virtually incomprehensible. I don't think the jury could have understood it. I don't think the lawyer who represented the defendant thoroughly understood it. I don't think the Commonwealth understood it. And I don't think the judge understood it.
Was there a voir dire before?
Yes.
There was.
There
Was
was
Mr. Robillard there?
Yes. As a matter of fact, Robillard comments on the voir dire and some of the statements that she made in that voir dire.
So he was present when she did it?
No, he was not present in the courtroom. He was not there. I provided it's in the affidavit. I provided the transcript of the voir dire and her
But
trial
at the
testimony.
time of voir dire, he was hired,
Yes.
but he wasn't present to hear it. Is that right?
I believe the answer is yes. There's certainly nothing in the record that he was present, but
Was he given a transcript of the voir dire hearing by trial counsel before the trial commenced?
no. Let me clarify. The voir dire occurred at the trial.
Oh, okay.
The voir dire occurred at the trial. He did not know. All this happened, including the suppression motion, happened at the trial. This was not something that was that took place well in advance of trial, so that the expert would have known. Gee, I should show up. But in any event, whether that was a trial decision. It was made by the lawyer for whatever reasons, which obviously are not in the record, and he was not called.
Are you saying that the prosecutor knew that this evidence was false and unreliable
No.
and put it on anyway?
Absolutely not. Matter of fact, there's a footnote in my brief addressing that. I don't think the prosecutor understood it either. The Commonwealth's expert walked in and basically said, she said it's probably him. Actually, it was a little more detailed than that. She said the person who prepared I may have it backwards, but the person who prepared the quote-unquote the exemplars, probably wrote the unknown, the Q1 document, Exhibit 11. There's nothing in the record to suggest that the Commonwealth knew just how bad this testimony was. That shouldn't insulate the Commonwealth, though.
Oh,
I mean,
it's fine.
this is serious testimony. This man was convicted based on this.
Well, how do you know
Isn't
that?
there a little bit more that he was convicted on than just this?
Well, we could certainly discuss that. There was other evidence, which, if believed by the jury, I addressed that in my brief, the motion for required finding of not guilty. But even let me say this: even if there was constitutionally sufficient evidence in this case, your review under 33E requires you to look very carefully at this affidavit and what happened on the motion for due trial. And there was no evidentiary hearing. There was no testimony. The Commonwealth never refuted anything in Alan Robillard's affidavit. That never happened. There's no evidentiary record on this.
Mr. Maidman?
Yes.
With respect to trial counsel's affidavit, as I read that, what he's saying is, even though the voir dire took place at trial, he could have called Robillard, because he said, I ultimately did not use Robillard's testimony because I did not believe that Bolsover had given an opinion of expert quality. So he must have felt that even during the trial, Robillard, he could have called Robillard. Right?
That's what the affidavit says. That's, yes. Yes.
Had Robillard told him beforehand that, in Robillard's opinion, Robillard had looked at...
Yes, he did.
And had Robillard given an opinion to defense counsel?
Well, that's not in the record. I can
Well, let
say
me
that,
put it
but
this way.
let me see if I can answer it this way. There's no question that Robillard went to the state police barracks, examined the documents, and this part's in his affidavit, looked at the documents to see if there was a source of this document. In other words, how did the transfer
This is
occur?
before trial?
Oh, yes, well
Okay.
before trial, and the dates
So
are in the affidavit. He went there, and this individual was the former head of the question documents at the FBI. He went out there. He went to Yarmouth. He went there, went to the state police, went in the box, examined all the documents, because his first mission as being a qualified forensic document expert, let alone a national expert, was where did this smudge come from? And he looked, and he couldn't find it. Okay, and so his next step is, following all the protocols and the standard utilized by forensic documents experts in most of the world, his first question was this natural writing? Okay, which is a defined term. It's explained
Yes.
in paragraph 46 of the affidavit. And he essentially said, I can't express a conclusion. Okay, I can't say whether it's him or whether it's a fabrication.
Well,
But my point is, you say it's not in the record as to what he had concluded beforehand. So one of two things happens. Either he has said to defense counsel, I can't express an opinion. And defense counsel knows that the Commonwealth's expert is going to say this lighting either is, or there's a strong likelihood that it is, the lighting, this reverse lighting, is the defendant's lighting. Even if you have one of the most highly trained experts saying, I can't express an opinion, surely that's helpful to the jury, because it's saying, a leading expert says, nobody can say that this is that. I mean, it's not, this is pretty hard science, correct? I mean, it's hard science, but it's not, it's in the area of where you have people who have expert.
Oh, sure.
Right?
That's
So
right.
again, I go back to, I don't understand why, if there's no ineffective assistance of counsel claim, you can simply ask us to say, well, it was so awful. Because I can't conceive of any set of circumstances, knowing that that the Commonwealth's expert was going to testify. You know, for the defense counsel to say, because I did not believe that Bolsover had given an opinion of, quote, expert quality. What does that mean?
I don't think I can go beyond the record on this. I think that's probably the best answer. And the only other thing that I would say is that no matter what the defense counsel did,
Okay.
this court independently is going to look at the case, and it's going to independently assess whether there was a miscarriage of justice in this case.
Okay.
And, Your Honor, my best answer to your question is, looking at the evidence that's in the record right now, all 126 paragraphs of it, a miscarriage of justice occurred in this case. I really can't go beyond that.
Okay.
Let me, before I go any further, let me mention a couple other points before my time
Could I
runs
just
out.
ask you one evidentiary
Sure.
point? It's not related to that exactly, but is there, was there evidence that the victim was indeed the person who testified at the custody, whatever?
Yes, there is evidence in the record of that. I think there's confusion over when she testified. The judge issued It's unclear from the record. But what is clear is that the judge issued the opinion on August, whatever, I think it's August 14th.
The probate judge, you're saying?
Yes.
August
That's right.
14th?
But she did testify. I don't think there's any question about that.
And that was before the jury. And did he lose custody as a result of that particular
There
proceeding?
was a lot of confusion about that. He had sued, he had sued for a modification. He wanted sole custody. He didn't get it. He also made allegations against his former wife, saying that there was neglect of the children, and the judge found against him on that too, based on, at least in part. Actually, I'm not sure where Linda Silva fit into it, but she did testify.
Okay. So,
But
and
for
that
the
was
Commonwealth,
all
yes,
before the
that's-
jury? That, in other words, on motive?
Yes, I think that's a fair statement.
Okay.
That's a fair statement. Let me...
And I just want to make sure I've got this right. He explained that he was at the scene of the crime that same day.
He was near.
Yeah,
that
afterwards.
is what the state police say, he said.
All right?
That is what the state police say, he says.
Well, that was
He
before
says
the
there's a
jury.
he says there's a tape recording of this.
That was before the jury.
Yes, that was before the jury, but that's another issue in this case. I filed, well before I filed the brief in this, the motion for new trial in this case, I filed a motion for favorable evidence, basically an exculpatory evidence motion, specifically directed to the tape recording. And eventually the Commonwealth filed an affidavit which said that the assistant district attorney was not aware of any exculpatory evidence that was not turned over to the defense. My motion was extremely specific, right down to the time of day when that tape recording was allegedly made, according to the defendant. And that motion was never addressed. There was no hearing on it. The matter would have been completely resolved, essentially resolved, if the police had said, there was no tape recording. But that's not what came back. And I would also I would suggest to this court that this court cannot decide this case unless they know whether a tape recording was made in this case and what was said. That's critical. He's basically placing himself at the scene of the crime, if you believe the state police. He's saying he didn't do it. And the record's bare. Let me go back one more time to
Well, when you say the record's bare, you filed the post-conviction motion. It wasn't the motion was docketed. There was the docket does not reflect that the judge ordered or that the judge allowed the motion for the exculpatory evidence. But there's a letter in the record from the clerk's office saying that the judge ordered the Commonwealth to produce exculpatory evidence, and then there's a Commonwealth's response.
I don't believe the letter says that. I don't have the letter in front of me at the moment. Okay, but the bottom line, the judge, the response was not there was no tape recording. This court does not know right now whether tape recording was ever made.
Okay, but there was no follow-up to that, to the Commonwealth's response.
But I certainly didn't follow up on it. I was waiting for the evidentiary hearing. This was sat around for, well, sat around is a bad word, but this case was around, was sitting for a year and a half. I had every expectation after filing an affidavit like this that there'd be some kind of hearing, especially on not only on the forensic document issue, but also on exculpatory evidence. And there's as far as I know, there's no rule of procedure requiring me to write follow-up letters saying, well, I don't agree with this, what else is there, that kind of thing.
Well,
at least I'm certainly not aware of that.
But
That was not my expectation.
But I guess one might ask if you were seeking specifically the tape and the answer you got back was a general answer, there's no exculpatory evidence, you might have followed up about, well, what about the tape?
I might have. But I thought my motion was so clear on this that I expected the judge to issue a ruling of some kind. And there was no ruling.
Was the Commonwealth's response received by you before the hearing? What was it? There was no
hearing.
Okay, so Judge Hinkle did this all on the papers?
That's right.
Okay.
There was no hearing. There was no opportunity for me to go any further on it. Next thing I know, I get in the mail the denial. Let me just briefly, in my few seconds remaining, say something about the motion for funds. There was no action on that. The Commonwealth, quite properly, did not take a position. Under Rule 30C5, the 2001 amendments to Rule 30, if Mr. Robillard's work does not qualify as raising a substantial issue, let alone the court can see what the man did. I just think that
Well, was it denied or just not acted on?
There was no action. There was
So it
nothing
needs
happened.
to be acted on, one
me?
way or the other,
No
right?
action at all.
No, but it needs to be acted on one way or the
Certainly.
other. Okay.
Certainly. And with that, Your Honors, unless the court has any further questions, I'll rest on my brief.
Thank you, Mr. Maven. Good morning, Ms. Holler.
Morning, Your Honors. May it please the Court, Julia Holler on behalf of the Commonwealth, to just address Your Honor's question about whether any sort of an opinion was expressed or that the defendant's expert, Mr. Robillard, knew what was going to be said ahead of time. During the voir dire, it's at Volume 1, pages 223 through 224, Attorney Segadelli, at the end of it, says, his expert would say that the witness, Bolsover, cannot say what she's saying. She can't give the opinion that she's saying, given the field of the science at that time. And he says, but my expert isn't here today. And this was at the initial voir dire, where there was extensive examination and cross-examination. Attorney Segadelli was essentially had the preview of the whole testimony and was in consult as his affidavit.
So the defense lawyer knows what the Commonwealth's expert's going to say.
Right.
He's already consulted with his expert,
Right.
who says what, I think it's a she,
Yeah.
says
He is Mr.
No,
Robillard.
I
The
know
Commonwealth's
that.
is
Is
the
the
she. Yes.
that her testimony is wrong, unreliable, whatever.
Well, it's not expert
don't-
testimony. It's
Right.
not-
It doesn't
it's-
rise
it's-
to the
it's-
level of an
it's all-
expert opinion.
it's
yes.
They don't call him at trial.
No.
They bring out his stuff afterwards in connection with a motion for new trial. Oh, going back, there's no motion to strike her testimony
No.
at trial.
And there was no objection at trial to the admission of these
She's
exhibits.
thoroughly impeached or cross-examined.
Right. And with due respect to my brother counsel, it seems to me that this is Mr. Maidman's, how I would have tried the case, and I mean that respectfully to Attorney Maidman.
Right.
I would have had this witness come and
So we would have to read
testify.
these proceedings and come away shocked.
Right.
Before we would say there's a due process violation.
That there was such a failing of an evidentiary presentation that the interests of justice
No, there's
here.
no claim of ineffective
And
assistance.
no, and there isn't any. It's just a failing of the evidence.
We are shocked because the evidence is so
Right.
false, unreliable, however you want to start.
Right.
How-
And I'm sorry, Judge.
You finish your sentence.
I was just say that it can't come in really unless you were claiming an ineffective assistance of counsel, and here he's not. It isn't newly discovered because of counsel's affidavit, and it was just a tactical choice. But it isn't even considered as a tactical choice because it isn't the ineffective assistance.
Well, Judge
analysis.
Henkel found it was strategic.
Yes, and she does find it strategic, so that kind of closes that door as well.
I know this is asking for your opinion, but in the scope of evidence, I wonder if you could just address the question of how, in your view, significant this piece of evidence was in relation to what other evidence there was tying this defendant to this crime.
Well, it's Bolsover talks what she does and how she brings it out, and it's how I prepared it to bring it out, but it's also almost a chain of custody testimony as well. What she actually develops is testified to by the defendant's ex-wife and then Claudia Dubois, who was his girlfriend of 9 years, who both testified extensively, and it's in my brief, the citations to the record, of that he made lists. He was a compulsive list maker, and he made lists, and we've seen his handwriting. Lisa Dubois, the ex-wife, for 6 years, Claudia for 9 years, and they are the witnesses who say this is his handwriting.
But they're looking at the photograph, at the enhanced photograph, not at
They're
the
looking at
original.
the exhibits, I believe, whichever the exhibits were. I'm not clear at this
Okay,
time.
but-
There were 2 exhibits, and they're looking at him, at the exhibits.
But
I'm
was the original piece before enhancement or before whatever, was that in evidence?
I can't think of that.
Okay.
I'm sorry, I
Okay,
don't know that off the top of my head right now, whether it was or not.
Well, I take it, Ms. Holler, that at least, and believe me, I haven't read the transcript, Judge Henkel points out 2 things that I think are problematic for the defendant. The one was his statement to his then-girlfriend that evening, "God forgive me, I'm sorry I
Yes.
did this to you." And when she said, "What on earth are you talking about?" he says it was about the kids.
About the kids, yeah, that's very
And then
strong.
the defendant, and I take it this is what she's referred to as Claudia, so I take
Claudia is the
the girlfriend.
yes.
No, I understand that, but I don't.
Right.
The defendant said to her when she was going to be interviewed, "Well, I was home for dinner. You know I was home,"
Right.
which he wasn't.
No, he was not home, but the
So-
jury could infer that he was trying to establish an alibi.
So in answer to Justice Botsford's question, and I can't at the moment find what the lighting actually revealed, but it's not. It doesn't say, "I'm going to kill X."
Well,
I mean,
it could be
focuses on-
considered very close to that, Your Honor.
Yes.
If I may find.
It says DSS caseworker screened out.
Yes, screened out. And that was, the jury could have inferred that that was obviously a hostility, or screened out was a term of art used by the DSS workers when they found that there was no violation, or there had been, an issue had not been proven. And there was also, in further answer to the response.
So if I'm sitting on the jury, what do I conclude the defendant has written, assuming that I accept that this is his handwriting?
That he's very angry, directed about this issue.
No, I understand that.
And it ties into his statement to Claudia, "God forgive me for what I've done, it's been for the kids." And then there's also a statement made to Claudia after another DSS hearing where he's, again, very worked up and very angry and emotional, as Claudia says. And there's, Claudia says after the way he was acting, she asks him, it's almost like you killed that social worker. And he says, "Wouldn't you like to know?" And it all ties into his hostility and his motive and his opportunity as to why he would focus this rage on the person whom he perceived as the one who had prevented him from having his children, and which gives intent and motive, and also puts some sort of a
Well,
explanation
there
on this
also, if I
act.
recall, this other evidence of perhaps linking him to the gun.
There was evidence that he
Evidence
had
that-
possessed a gun that was of the same
the vehicle
caliber.
that was seen leaving the scene
Yes.
could have been one of his vehicles.
Right. It was similar. It was not pinned
That
down.
the
to things,
shadowy description that people were able to get,
and that he was not wearing clothes.
yeah,
When he came
vaguely
home.
matched him.
Right.
So
There,
okay.
there,
What did he say he did with his clothes? I can't remember.
he said he told Claudia it was obviously strange for him to come in without it. He just had his long johns on. He said he'd gotten dirty at work, and that was his only explanation for it, of not having his work clothes on. He said
So
he'd
there's
gotten
lots of other evidence of circumstantially and otherwise
Oh, sure.
links him to this crime.
Sure, there is, and his statements themselves are very strongly,
Very,
very
very
damning
powerful.
at this point.
Okay.
As to just to the point of the affidavit and the post-trial discovery request, certainly the Justice Hinkle, in looking at that, was entitled to consider the defendant's affidavit as very suspect and not credible, given that it would have been highly reasonable for the defendant to have jumped up and down with his attorney, because all of this evidence came out about this interview, where he does place himself in Provincetown at the night, but he says he was there, and he even walks by the murder scene, but it was later and after everything had been finished up. And there's no questioning whatsoever, did you have a tape recorder, did you do any of that sort of thing? And clearly, if for the defendant's argument to be credible now, his affidavit, it certainly would have been reasonable for him to have raised that issue about the taping then, while he had his counsel right there.
As a matter of, what struck me as a little curious, though, is after he, in the post-conviction motion for exculpatory evidence that the Commonwealth responded to, the Commonwealth's response doesn't say there is no tape recorder. They simply say there's no exculpatory evidence. I mean, why wouldn't with such a specific motion, why wouldn't the Commonwealth say there is none?
I can tell you, I was involved in that with all due respect. That was the affidavit I was given in response to, by the trial attorney, and that
Oh,
was
it's-
the
it's
way
a
it had to end for me to present.
It's a sloppy answer, but,
I was not able to get any other answer out of the trial attorney, or the trial attorney who was one of my superiors. That's what he gave me and what I had to work with.
okay.
So I can't, I'm going a little beyond the record, I apologize, but that's what I was given to work with, and that's what we put on the record. There was no request for a clarification. There was no objection to what the Commonwealth filed. It was still open at that point. And if Your Honors have no further questions,
you.
I will
Thank you, Ms.
rest
Hunter.
on my record. Thank you.